Thank you very much, Daniela. Our next expert is Kabir Joshi, who joined Wilson Solicitors in 2016. He's a solicitor with a caseload of immigration, asylum, and human rights law cases. He has experience in assisting vulnerable clients, such as victims of trafficking, of torture, and those with mental health problems. He specializes in national security work before the Special Immigration Appeals Commission. And he also has a particular interest in cases involving those fleeing political persecution, deportation, and challenging detention. Kabir, you're up. Thank you.
Hi, can you hear me okay? Yeah. Thank you for inviting me today. Yes, as Freya said, I'm a solicitor at Wilson Solicitors in London, with a predominantly legal aid practice. My focus is immigration and public law. I'm going to maybe describe some of the work I do and I think maybe that would be helpful for you to understand whether it's something that would also interest you. But before doing that, I thought I'd briefly just say a little bit about my journey into law, because it may sound abnormal, but it's not, and it's important for people to know that you don't always have to have basically studied law before getting a job as a caseworker in some of these human rights, immigration, public law firms. So yeah, I got a job basically straight after I finished my undergrad 7 years ago, and I hadn't at that point done the GDL or the LPC, and then I proceeded to do that while working full-time, do the GDL and the LPC part-time over 4 years. So that was 4 years of weekend university and lots of exams, and yeah, it was obviously not fun, but yeah, I've just asked before if I would do it again, and I actually probably would, and that's because I really enjoy the work that I do. And so I'll tell you a little bit about that now. Basically, I have two main focuses that I've worked on over the past few years. The first is immigration detention, and the second is work before SIAC, the Special Immigration Appeals Commission. So firstly, with detention work, I and other solicitors and even level 2 caseworkers at my firm will go into a detention center and conduct something called a legal aid detention advice surgery. So that's where you see 10 detainees and provide advice to them within half an hour slot. So you're trying to read all the papers they bring you, provide very quick advice, but also see whether they're eligible for legal aid, and whether you can assist them in the future with their cases. You can get really all sorts of cases in detention. You see some of the worst examples of UK sanctioned state violence within the UK, I think. Some of the cases that really have taken me is working with people who have often grown up in the UK and then might have committed a criminal offence as a teenager, and then not having regularized their status as British citizens. They might be of Somali backgrounds or Jamaican backgrounds or other places as well. They then receive a deportation order in respect of, say, Somalia. I've had 2 cases where that happened, where the 2 detainees had never actually been to Somalia before, didn't speak Somali, didn't have any connections in Somalia. One of them was a victim of trafficking. He had been trafficked for criminal exploitation known as county lines, drug trafficking as a minor. And yeah, so that I could go into more detail about those cases, but probably maybe in the Q&A or afterwards, if anyone's interested, I can expand on that. But yeah, you do see examples of injustice which maybe you wouldn't expect. For example, you probably wouldn't expect someone who's been here since the age of 2 to be receiving deportation orders in respect of Somalia. And if you speak to these people, they're as British as anyone else you can imagine. So, yeah. And the second piece of focus I have that I would like to talk to you today about is the Special Immigration Appeals Commission, which basically presides over cases relating to national security. Crucially, its procedure rules allow for closed evidence, so that's classified evidence, that the appellant and the what's known as open legal representatives, which is the appellant solicitor and barrister, will never be able to see. They do have closed proceedings where they look at the classified evidence, and the appellant is represented by a barrister known as a special advocate in those proceedings. But the special advocate can never take instructions from the appellant or really speak to us either, because essentially the information is all classified. And then there's an open judgment, which we can all see, and then there's a closed judgment, which we will never see, and the appellant will never see. And often the closed judgment contains most of the incriminating material that the judges decide to uphold the deprivation of citizenship decision. Obviously, the most famous recent, or probably maybe ever, SIAC case is the Shamima Begum case, which I'm sure you've all have heard of. So I've basically worked on 3 deprivation of citizenship cases, 2 of which U3 and P3 are in SIAC and the Court of Appeal, and have been central, along with Begum, to the current jurisprudence on deprivation of citizenship. So these cases are kind of bouncing between SIAC, the Court of Appeal, and the Supreme Court, hopefully. And the developing case law is very interesting, but I probably don't have enough time to go through all of that and do it justice anyway in this session. But I would like to just focus on quite a few of the kind of examples of how unfair SIAC procedures can be, because it is, I think, very interesting. So obviously, as I mentioned, the closed procedure rules make it very difficult to represent an appellant, for the reasons I already said. You can't really take instruction from someone on charges or evidence that they have not had sight of. That doesn't really exist in many other fields of law anywhere in the world, as far as I know. But then also there's the discriminatory aspect of it. When you think about who can and can't be targeted by deprivation of citizenship orders. So this is obviously, you can't be deprived of your citizenship if you are to be made stateless. But in the Begum case, basically, SIAC decided that, well, they look into whether you have an entitlement to another nationality. So Shamima Begum never had Bangladeshi citizenship, but SIAC spent a long time as a preliminary issue looking into whether she could, in theory, apply for Bangladeshi citizenship. This was despite the Bangladeshi government very clearly stating that they would never grant her citizenship. But there's previous case law that says, in effect, it's not the UK government's fault if another country won't abide by their own nationality laws. So they spent a long time looking at British Indian nationality law, Pakistani nationality law, independent Bangladeshi nationality law to decipher what if she could apply for Bangladeshi citizenship. And they decided that until the age of 21 she could. So on that basis she wouldn't be made stateless, whereas if she had been over 21 she would have been made stateless, ironically. And that was just a preliminary issue in the Begum case, but I think it goes to show quite how wild some of the jurisprudence in SIAC is. And then finally, the other really complex and quite unfair thing that happens in SIAC is that unlike in normal appeals, SIAC is subject to public law principles. So this makes it significantly harder for the appellant to be successful, as effectively to prove that the Secretary of State's deprivation of citizenship decision, they have to prove basically that it's irrational. And that's obviously a very difficult test to make, because the appellant also has to do this in the context of SIAC having to give deference to the Secretary of State's national security assessment as the body in this country which is there to protect the public. So there's therefore a tension within SIAC which requires the application of the principle of public law, but also one of procedural fairness, where as in an ordinary appeal, you'd expect further evidence to be supplied and looked at by the court post the deprivation decision. And this happened in the case that I worked on, U3, where essentially the judges in SIAC accepted her account that she had been coercively controlled, physically abused and emotionally abused by her husband, and therefore followed him to Syria, but ultimately said it wasn't for them to challenge the Secretary of State's national security assessment, and that they couldn't make findings of fact which basically undermines the national security assessment, which obviously begs the question as to why we would have an appeal at all. So yeah, I mean, that's, I hope not, I realize that maybe we've gone quite deep into some of the like unfair things that happen within SIAC, and I don't mean to go on too much. But yeah, I just wanted to give you a bit of a flavor of some of the work that I've been doing. And yeah, maybe we could discuss in the drinks later if you had any questions. Thank you.